Good morning, everyone. Morning. Apologize for our late start, but Seaborne delayed some of their flights, so Justice Willox had some difficulty arriving. So we will start with the calendar, and we will proceed in the order in which they are listed. And the matter of Clark, Williams, Mapp, et al. Versus Fidelity and Guaranty Insurance Adjusters, Underwriters doing business as travelers. So, Attorney Jackson, you're ready to proceed. Wish to reserve any?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay.
May it please the Court, my name is Frank Jackson. I'm here on behalf of the appellants with respect to this action for breach of contract. What happened here, Your Honor, is there was an accident back in November of 2013 wherein my clients, then plaintiffs, were injured as a result of that accident, and they filed suit in June of 2014. They amended the complaint in August of 2014. Before they filed suit, Mr. Jones, who was the insured, who had rented a car here in the Virgin Islands, he was not driving that car. That car was being driven by his hotel mate, the one who traveled down here with him, Mr. Kasim Turnbull. He was driving that car on that day, that rental car, and he had that accident. Now, after that accident occurred, Mr. Jones, as per his obligations under his insurance, he alerted the insurance company about that accident. Within 1 month of alerting them of that accident, he alerted them on the day of the accident or the day after, thereabouts. Within a month of that, the insurance company contacted him. They met with him. They had him provide an affidavit that said that the car was stolen by his hotel roommate, if you will, the person he traveled down here with. And as a result of what they said, that car was stolen and other conditions under the policy, they said to Mr. Jones they were going to deny him insurance coverage for that particular accident. They further said in that letter, and that letter is dated March 10th, 2014. And I should emphasize that that letter was served on Mr. Jones before any lawsuits were filed. And we submit that's important because the duty to defend Mr. Jones does not arise until a lawsuit is filed against him, which triggers the obligation to defend against that lawsuit. They sent him a pre-lawsuit letter saying we're denying coverage. However, when and if you get served with papers, bring them to our attention, and we'll reconsider whether or not we're denying coverage based on the facts and circumstances as well as the conditions and terms of the policy. Well, we submit Mr. Jones, when he was served with that underlying lawsuit, he presented it to his insurance company. They never provided him a defense. Ultimately, Mr. Jones was required to represent himself in that matter, in the underlying automobile accident. And he did represent himself, and he went to mediation, and he resolved that underlying claim for $75.
Did Jones ever demanded that travelers offer him a defense?
Of course he did, Your Honor.
How was that done?
He provided them with notice that he had been sued. They have not said they said, the attorneys in their pleadings say he never demanded representation. We say he did. When he told them about the accident, that was notifying them of the accident. When he met with them a month later and gave them an affidavit saying that his vehicle was stolen.
Was that with respect to the suit in New Jersey, or was it with respect to this claim here in the Virgin Islands?
It was the underlying claim he was supposed to give them notice of. It was the underlying claim They say he never gave them notice. We say he did. We say that's a question of fact, whether notice was ever given. That's a question of fact for the court, the Superior Court, to determine whether there was notice given and whether or not there was a breach of the duty to defend after that notice was given. That, we say, is not an issue per se for this court. This court's issues are whether or not there was a lawsuit filed, and whether or not the appellees had an obligation to defend that lawsuit, which we say they received notice of. And when they did not step in to defend that lawsuit, Mr. Jones was left with defending himself. He went to mediation.
Okay, we understand that it was assigned to you, and then you amend your complaint and you brought suit directly against Travelers.
Yes.
And is Crawford still in the case or not?
No.
Okay.
The Superior Court addressed issues regarding the claims against Crawford, and we accept the Superior Court's determination with respect to Crawford. This case is strictly against Travelers.
You claim that the court decided the case on the merits and considered matters outside of the pleadings. What matters outside of the pleadings did it consider?
Twofold, Your Honor. They accepted that affidavit from Mr. Jones that his car was stolen from him, as opposed to his hotel mate having either implicit.
Did you include discussion about that in your complaint?
What we talked about is that he was sued, and they had an obligation if the four corners of the complaint set forth a claim for breach of contract. And we say he notified him of that. They then had an obligation.
So tell me
to defend.
what matters outside of the pleadings
second one, Your Honor.
did the court consider?
Well, the second.
You're saying, one, this letter or this handwritten affidavit was considered by the court, and that was not included in the complaint?
No. Right, Your Honor, yes. They also considered the letter from Crawford, which was an adjusting agency that adjusted this claim to determine whether or not there was coverage. That's the letter I referred
You
to.
didn't attach that to your complaint?
Your Honor, we did have them all in our appendix. So all these, yes, these documents were attached in the complaint initially. The underlying complaint.
So the court could consider them if they were attached to the complaint?
They can consider them, Your Honor, but consider them for purposes of the motion that was pending before them. The other thing they didn't consider, Your Honor, or they took into consideration, was that letter, the affidavit I mentioned, and they basically made a determination that he never gave us notice. We say he did. That's a question of fact that the court should not have made a determination on. That's what the case was all about, whether or not they breached the contract.
Well, the court never reached the statute of limitations.
And that's the problem, Your Honor. Excuse me, Your Honor, I do apologize. They did.
What did the plaintiff's appellants contend triggered the running of the statute of limitations?
We say it was not from the initial denial that was filed, that was served even before a complaint was filed. It's only after the complaint was filed in June of 2014 that some correspondence had to come from Travelers to deny the claim. And that came November 3rd, 2015, when they specifically said, we're not providing you with a defense. Get your own attorney. We're not providing you with the defense because we say there's no coverage. We say November 2015, the complaint was...
Let me ask you this. If the operative date is November 3rd, 2015, did you include that date in your complaint or amended complaint?
That's yes, Your Honor. We did talk about when we say the statute of limitation, when the statute would start to run, and therefore how much time we had thereafter. We had 6 years from the date of notice of the denial. And yes, we say that we did include that we filed this case within the 6-year statute of limitations that is set forth for breach of contract. When the court addressed that issue of statute of limitations, they addressed it for all of the claims, but they did not address it for the breach of contract or the bad faith. They said those were 6 years statute of limitations, but did not then say when the statute began to run and therefore when it would have expired. They just didn't address it. They took the next step and said, we say there's no breach of contract because the travelers submitted the affidavit saying that the car was stolen. They submitted the report from the adjuster saying, we looked into this and we say there's no coverage. Based on that, on their one-sided, self-serving submissions, the trial court said, yes, you're right, there's no breach of contract. And we submit that's what the whole case is all about. That would allow plaintiffs to have, plaintiffs or appellants, excuse me, to have discovery, to have depositions, to have formal motions for summary judgment, you know. But the court sort of put all that aside and went immediately to determine the underlying facts of whether there was a breach of contract. We say the court overstepped its bounds, if you will, abused its discretion when it did so. So
Thank you. Thank you.
thank you.
Proceed.
Thank you, Your Honor. Good morning, Chief Justice and Justices of the Supreme Court of the Virgin Islands. May it please the Court. My name is Siobhan Thomas, and I represent the appellee, Fidelity and Guaranty Insurance Underwriters doing business as travelers. We submit, Your Honors, that this Court should affirm the Superior Court's dismissal of my client, Travelers, and that this appeal should be dismissed outright for two very fundamental and independent reasons. One, appellants have failed to establish a breach of contract because there was never a demand that was made of Travelers to defend. Two, they have waived and or failed to preserve critical arguments below, including the issue now raised on appeal regarding the duty to defend. Attorney Jackson made several arguments regarding the documents that were attached to the complaint, Your Honors. As you all have already astutely noted, that these documents were submitted by the plaintiff first. Now that the court relied on those documents in order to dismiss this case and to evaluate this case, now we have an issue with the documents that were submitted.
Did the affidavit indicating that the vehicle was stolen and that no permission was given, was that included in the complaint? Or was that attached to your motion?
That was included in the complaint, I believe, Your Honors. It was at least referenced in the complaint. There's another kind of fundamental issue here, which is that the appellant refers to the amended complaint throughout his brief. There was absolutely no point that the court actually accepted the filing of the amended complaint. This case, and the reason why we're here today, is the complaint that was originally filed in the court. In the amended complaint, he actually attempted to fix several of the, I guess, arguments related to his statute of limitations argument. But that cannot stand. The court did not accept that complaint, Your Honor. I hope that answered your question.
Not sure, but go ahead.
The essence of a breach of contract claim under the Virgin Islands law requires the existence of a duty and a breach of that duty. Here, while James Jones did not have an insurance policy, did not hold an insurance policy with Travelers, or Kasim Turnbull, I apologize, did not hold an insurance policy with Travelers, no duty to defend could have been breached because James Jones did not make that demand for the insurance policy to defend following the presentation of the complaint. In fact,
Why did the insurance company hire Crawford if they didn't get notice that there was an accident and then,
Because there was that notice that litigation existed, Crawford was specifically hired to investigate the claim and adjust the claim. And that's what they did in this case. There was a full investigation that was performed. The result of that investigation that was performed was that there was no coverage in this specific incident.
When did the insurance company receive notice that a complaint was filed?
The insurance company received notice. The date is escaping me. However, my understanding is that there was the notice after the mediation in 2018. I do believe, in addition, there was notice prior to Crawford being hired to adjust the claim, of course. As to a specific date, I do not have that on me as to the insurance company's specific first notice. But they did act. The record shows that they did act upon that notice. In addition, that was an issue of fact that was not fully litigated or even brought out in the litigation because there was that history of appellants failing to respond to several of the motions of both Travelers and Crawford.
you filed basically a 12B6 kind of motion, right? And the court correctly recognized that this is a notice pleading jurisdiction and that the only purpose of the rule 12B6 is to test the pleadings.
Yes,
And
it is.
that they don't necessarily reach the merits. But in this case, the court did, in fact, reach the merits. It did not address the statute of limitations except for the 2-year statutes. And then went ahead and resolved the matter on the merits, finding that there was no duty. Wasn't that, in effect, converting this to a Rule 56 summary judgment motion without notice to the parties that it was going to do that?
It could have been interpreted that way. I would agree that there was some level of a conversion that did occur. The other part of that, though, is that during the May 9, 2022 hearing, the court did recognize on the record that, one, we had all of these documents that had been submitted to the court, not just by the appellees, but also by the appellants. And there wasn't a dispute at the time as to whether or not these documents were valid documents. I mean, in appellant's argument, he calls the letter that he submitted as part of his filing a letter that was legally invalid. If it was legally invalid, why submit it to the court for the court to examine it? You know, you have to, when you submit a document to the court.
Who determined that it was legally invalid?
I'm sorry, Your Honor?
Who determined that the document was legally invalid?
Exactly. There was no argument and no determination that the document was legally invalid. This is what the appellant stated in his brief, that this was a legally invalid document.
Are you saying that the documents that you produced with your motion to dismiss are part of the pleadings that the court can consider on a motion, on a 12B6 motion?
Yes, Your Honor, especially if they were documents that were originally submitted by the plaintiff.
Well, was the handwritten affidavit saying that the car was stolen, was that ever presented by the plaintiff? Or was that simply attached to your motion and that the court relied heavily on that, in her opinion, and finding that there was no duty?
It was submitted for the completion of the record. So the letter from May 10, 2014 does reference that affidavit. So there was a bit of a hole in the record. I'm not 100% sure it was submitted, and I would need a minute to brief that. But I do know for sure that May 10, 2014 letter specifically references that affidavit as part of the investigation and the reason for the determination that was made by the adjuster.
And those correspondence had to do with the case that was filed in New Jersey
Yes, Your Honor.
by Budget seeking, to reclaim the damages that it occurred to its vehicle. Is that basically?
Did you say the last 6 words of what you said, Your Honor? I'm
Well,
so sorry.
All of this correspondence initially began because Budget filed an action against Mr. Jones in New Jersey,
Correct.
and these correspondence was relating to that action, correct?
It arose out of that action, but our position is that it related to this specific incident that occurred here in the Virgin Islands. And in addition to that, Mr. Jones did receive proper service of that correspondence. He affirmed receipt. And in addition to that, he actually did what the letter instructed, which was if there's ever any issue that occurs in the future or any sort of litigation that occurs in the future, contact us immediately.
Well, if I understand the plaintiff to be saying that because of that last paragraph, which said, if you are sued, notify us of the complaint, that somehow indicate that it was not denying coverage or a defense, and that determination would be made when they actually received a lawsuit.
Essentially, what I'm hearing from plaintiff, well, appellant, as part of his argument, is essentially anytime there's a new lawsuit, essentially that request would renew. Our position would be that
But
that's
isn't
just not
that what the insurance letter said to do?
To contact immediately, yes, it did. But I believe this comes down to a question too, which could have been litigated in the Superior Court, but it was not. Does every single time there's a brand-new lawsuit reinvigorate a question that you asked someone back
There may
in
be different claims, so denial in one isn't necessarily denial of all claims in the future.
As to this incident, I would state so because of the facts. As the appellant provided, the facts are James Jones was not the person that was driving the vehicle. We agree. In addition to that, that vehicle was taken by Kasim Turnbull. The appellants did not argue in the lower court appropriately that this was some sort of, that James Jones allowed him or gave him the keys. There was never,
Basically, the keys were on the desk in the hotel room that they were both staying in, and he took the keys from the desk and went with the car while Mr. Jones was asleep, I guess.
correct, and he was not an additional insured, and he did not seek permission of James Jones. Yes, sir. Yes, sir.
But as I understand it, they're saying there was implied consent. The affidavit made it seem like he got the keys from the front desk and took off with the car, and he knew nothing about it.
Well, Your Honor, I think it's fair to believe that if you're in a room and you're sleeping there every night, you should be able to put your stuff down and go to sleep. I don't see there being any sort of implied permission for James Jones to take that car. If he was an additional insured on the policy, or if he was actually listed, that would be different. I think that would be a different set of facts, but we don't have that here. This was a vehicle that James Jones rented. He was the person that was the driver of the vehicle. There's not any evidence that he drove the vehicle any other point except for that very night when that incident happened, so seemingly for good cause.
Allowed to address the merits on a motion to dismiss?
I believe my understanding of the case law in the Virgin Islands is that the court has to assume that everything that's in the plaintiff's complaint is true. For me, if you attach documents to your complaint, then the court should be able to assume that the documents are true. But I do.
Or the documents attached to the
There were
documents
documents.
attached to the complaint?
Yes, so that's what the plaintiff appellants.
Well, either it was or it wasn't. I mean, he lists all the exhibits that were attached to the complaint, and I don't believe that this affidavit of Mr. Jones saying that the car was stolen was attached to the complaint. It was attached to your motion,
Yes, yes.
and I don't believe that the court can take documents that you attached to a motion to resolve a matter under pleadings.
Yes, Your Honor. So while the affidavit may have been attached to my pleading, which was the document that was part of the investigation by Crawford.
Regardless of what it was something that was not part of the pleadings. And if you're going to resolve a motion on the pleadings, when you consider matters outside of the pleadings, you're actually converting it to a Rule 56 motion for summary judgment. And the rules require that before you do that, you have to give notice to the other party that you're going to convert it and allow them to respond. So the question that Justice Cabret asked you is, can you go beyond the pleadings to resolve a 12b6 motion?
So I believe that in this case specifically, there may be an issue as to the affidavit. I would agree with Justice Cabret. There may be an issue there, but overall, the controlling document, when we're talking about whether or not there was a breach and whether or not there arose this duty to defend, is that March 10, 2014 letter.
That's what you say, but they're saying that it was only after the case was filed and they then wrote a letter saying, we're not going to defend you on it, that is the starting date. So at least it's not a question of fact as to that.
As to the March 10, 2014
As to
letter?
when the statute began to run, basically, because that's what it is.
When the statute began to run, may have been an argument that could have been developed further in the record when everything was filed, but really, part of why we're here is because the appellants waived so many of those issues by not responding. The court requested again and again that there be that response to the pleadings and the documentary evidence and what was there. And I understand, this court's position, which is you have a bit of an undeveloped record, but that record is undeveloped because appellants didn't develop it, Your Honors.
Thank you.
Oh, may I conclude, Your Honors?
Yes.
Briefly. In conclusion, this appeal should be dismissed for lack of jurisdiction, failure to preserve the issues, and because appellant's own inaction prevents a claim for breach from proceeding. This is not a question of disputed fact, it's a question of undisputed inaction. Even if the court were to convert the motion to one for summary judgment, there really are no material facts that are in dispute here. Thank you, Your Honors, for hearing from us.
Attorney Jackson? You got- Attorney Denzing, you have, you're not part of this anymore, right? So, okay. No, yeah.
Yeah, good morning, Your Honor. Based on the representations from appellant that Crawford that they have no active claims against Crawford and they accepted the judge's ruling, I don't think there's anything left for us to address.
Thank you. I thought you were coming to put yourself back into the case.
No, thank you, Your Honor.
Okay. Okay, Attorney Jackson, you still have 5 minutes.
Thank you, Your Honor. The appellee made a position that the amended complaint was never accepted by the court, but there is an order that accepted it. All of the appellee's moving papers were in response to the amended complaint. Even though the court had not, the plaintiff had not asked the court to allow the amendment was ultimately accepted by the court, and the court made reference to the fact that all of the defendant's paperwork went to the amended complaint. Breach of duty, Your Honor, that's what the whole case was all about. The court went beyond the complaint, which set forth the breach of contract and bad faith, to which the travelers agrees. Travelers says this court lacks jurisdiction because this matter, that the breach of contract claim, bad faith, should still be in the Superior Court. We agree it should be there, just like they say it should be there, except they say this court has no jurisdiction because the claim should still be there. But we have a final order, Your Honor, by the court that closed that case, dismissed that case. That's as final as an order can get. We had every right to come to this court to appeal it, and that's why we're here now. The court made reference to it being a notice jurisdiction, and that's, of course, right. You look at the complaint to determine whether or not there's any breach of contract duty to defend. You don't look to a letter from the insurance company that says, we don't have it, especially if it's filed before the complaint. In fact, the appellee made reference to that the actual policy is not before the court, that it wasn't before this court here because it's not relevant to these proceedings. If the actual policy has never been before a court, then the lower court could not have looked at the facts and circumstances, compared it to the policy, and then determined there was no duty. When we say a letter was legally invalid, Your Honor, what we were referring to is this, that it's legally invalid for purposes of giving notice if it's, for giving notice that you're not going to defend, if it's given to the, your insured before he's sued. So anything that comes to the insured before there's a lawsuit is of no moment, legally invalid, if you will, Your Honor. Once the lawsuit is filed, then comes the duty to defend. And what Travelers is asking us to believe, Your Honor, is this, that Mr. Jones told them fairly shortly after the accident about it, that within a month he gave them an affidavit saying the car was stolen, that when he was sued by Budget and gave them the papers, they sent him a letter saying, we told you previously and we're telling you again, we're not covering you. What we say is, where is the letter that said you're denying his action to be defended in the underlying action? There is none on that. The only formal notice we have is the November 5th, 2015 letter. That's when the statute begins.
You agree that when you accept the assignment, that you step into Mr. Jones's shoes, correct?
Exactly, yes.
So when he received notice, you would agree that that notice is binding on you?
Yes, yes.
Okay. And the court didn't reach this. I thought it would have been an easier way to get, to resolve the case, is to determine when the notice was given and found that it violated the statute or it didn't. But it was also a motion for failure to state a cause of action, right?
Yes.
And that would have been failure to state a cause of action for breach of contract.
Yes.
So when the court resolved that issue and found that, well, there was no duty here, so there's no contract, and therefore you can't prove it, why isn't that proper?
Because the court didn't allow any discovery. They saw the complaint set forth a valid claim for breach of contract. They acknowledged that. They saw some documents from the Travelers that said we did an investigation and we believe the car was stolen, and that's enough for the court to determine there's no breach of contract. We submit that would be their evidence in a hearing on the merits, and the plaintiffs would have the right to submit their evidence on the merits. And their primary evidence will be Mr. Jones's testimony that he gave them notice of the lawsuit, just like he gave them notice of the accident, just like he gave them notice of the Budget lawsuit. Why would he not give them notice of this one? So that's a critical factor to determine the issue of the statute of limitations.
Well, the court didn't really resolve the issue of statute of limitations, so I'm not, asking about that. I'm just asking why, if everything is in the complaint sufficient, you refer to that letter, that affidavit that said the car was stolen, you refer to that in your complaint, even though you didn't attach it. So when the court looks at the pleadings and says, well, I don't see a duty here,
Your Honor, merely because they say that it was stolen does not mean that the plaintiffs would not be allowed to challenge that through Mr. Jones's testimony or Mr. Turnbull's testimony. A car being stolen means, Your Honor, you intend to deprive the owner of that car permanently. Not that you stayed in the same hotel room with him, went out on your own, and then was coming back later to sleep in the same hotel room that you always slept in with him before you flew back to New Jersey. There's no theft there. There may be an unauthorized use of a vehicle, but that's a question of fact, whether or not he had authority to use that vehicle or whether it was implied authority. He's on vacation with them. They rent one rental car. They don't rent each one of them. They're driving and traveling together. Those are factual questions that have to be determined, Your Honor, whether it was an impermissible use of the vehicle or not.
Okay, thank you.
Thank you.
Okay, the matter will be submitted.